So welcome to the chapter number 38, that is Panchayati Raj. The term Panchayati Raj in India signifies the system of rural local self-government. It has been established in all the states of India by the acts of the state legislatures to build a democracy at the grassroots level. It is entrusted with rural development. It was constitutionalized through the 73rd Amendment, Constitutional Amendment Act of 1992. Evolution of Panchayati Raj. Balwant Rai Mehta Committee. In January 1957, the Government of India appointed a committee to examine the working of the Community Development Program 1952 and the National Extension Service 1953 and to suggest measures for their better working. The chairman of this committee was Balwant Rai Ji Mehta. The committee submitted its report in November 1957 and recommended the establishment of the scheme of democratic decentralization, which ultimately came to be known as Panchayati Raj. The specific recommendations made by it are establishment of a three-tier Panchayati Raj system, Gram Panchayat at the village level, Panchayat Samiti at the block level, and Jila Parishad at the district level. These tiers should be organically linked through a device of indirect elections. The village panchayat should be constituted with directly elected representatives, whereas the Panchayat Samiti and Jila Parishad should be constituted with indirectly elected members. All planning and development activities should be entrusted to these bodies. The Panchayat Samiti should be the executive body, while the Jila Parishad should be the advisory, coordinating and supervisory body. The district collector should be the chairman of the Jila Parishad. There should be a genuine transfer of power and responsibility to these democratic bodies. Adequate resources should be transferred to these bodies to enable them to discharge their functions and fulfill their responsibilities. A system should be evolved to effect further devolution of authority in future. These recommendations of the committee were accepted by the National Development Council in January 1958. The council did not insist on a single rigid pattern and left it to the states to evolve their own patterns suitable to local conditions, but the basic principles and broad fundamentals should be identical throughout the country. Rajasthan was the first state to establish Panchayati Raj. The scheme was inaugurated by the Prime Minister on October 2, 1959 in Nagar district. Rajasthan was followed by Andhra Pradesh, which also adopted the system in 1959. Thereafter, most of the states adopted the system. Though most of the states created Panchayati Raj institutions by mid-1960s, there are differences from one state to another with regard to the number of tiers, relative position of Samiti and Parishad, their tenure, composition, functions, finances, and so on. For example, Rajasthan adopted the three-tier system, while Tamil Nadu adopted the two-tier system. West Bengal, on the other hand, adopted the four-tier system. Further, in the Rajasthan Andhra Pradesh pattern, Panchayat Samiti was powerful as the block was the unit of planning and development, while in Maharashtra Gujarat pattern, Jila Parishad was powerful as the district was the unit of planning and development. Some states also established Nyaya Panchayats, that is judicial panchayats, to try petty civil and criminal cases. Study teams and committees. Since 1960, many study teams, committees and working groups have been appointed to examine the various aspects of functioning of Panchayati Raj system. तो यहाँ पर वो डिटेल्स यहाँ पर दिया गया है. Ashok Mehta Committee. In December 1977, the Janata government appointed a committee on Panchayati Raj institutions under the chairmanship of Ashok Mehta. It submitted. अच्छा, ये अशोक मेहता का वही है क्या? आई थिंक जो जिसकी इंटरव्यू ले रहा था वो, अरे 12th फिल्म मूवी में मनोज कुमार शर्मा, तो वहाँ पर था ना अशोक मेहता. I think वही होगा. It submitted its report in August 1978 and made 132 recommendations to revive the strengthen the declining Panchayati Raj system in the country. Its main recommendations were the three-tier system of Panchayati Raj should be replaced by the two-tier system, that is Jila Parishad at the district level, and below it the Mandal Panchayat consisting of a group of villages with a total population of 15,000 to 20,000. A district should be the first point for decentralization under popular supervision below the state level. Jila Parishad could be the executive body and made responsible for planning at the district level. There should be an official participation of political parties at all levels of Panchayat elections. The Panchayat Raj institutions should have compulsory powers of taxation to mobilize their own financial resources. There should be a regular social audit by a district level agency and by a committee of legislators to check whether the funds allocated for the vulnerable social and economic groups are actually spent on them. The state government should not supersede the Panchayati Raj institutions. In case of an imperative separation, elections should be held within 6 months from the date of separation. The Nyaya Panchayat should be kept as separate bodies from that of the development panchayats. They should be presided over by a qualified judge. The chief electoral officer of a state in consultation with the chief election commissioner should organize and conduct the Panchayati Raj elections. Development functions should be transferred to the Jila Parishad and all development staff should work under its control and supervision. The voluntary agencies should play an important role in mobilizing the support of the people for Panchayati Raj. A minister for Panchayati Raj should be appointed in the State Council of Ministers to look after the affairs of the Panchayati Raj institutions. Seats for SCs and STs should be reserved on the basis of their population. A constitutional recognition should be accorded to the Panchayati Raj institutions. This should give them the requisite status, sanctity and stature and an assurance of continuous functioning. Due to the collapse of the Janta government before the completion of its term, no action could be taken on the recommendations of the Ashok Mehta committee at the central level. However, the three states of Karnataka, West Bengal and Andhra Pradesh took steps to revitalize the Panchayati Raj, keeping in view some of the recommendations of the Ashok Mehta committee. G.V.K. Rao committee. The committee to review the existing administrative arrangements for rural development and poverty alleviation programs under the chairmanship of G.V.K. Rao was appointed by the Planning Commission in 1985. The committee came to conclusion that the developmental process was gradually bureaucratized and divorced from the Panchayati Raj. This phenomena of bureaucratization of development administration as against the democratization weakened the Panchayati Raj institutions, resulting in what is aptly called as grass without roots. Hence, the committee made the following recommendations to strengthen and revitalize the Panchayati Raj system. The district level body, that is the Jila Parishad, should be of pivotal importance in the scheme of democratic decentralization. It stated that the district is the proper unit for planning and development and the Jila Parishad should become the principal body for management of all development programs which can be handled at the level. The Panchayati Raj institutions at the district and lower levels should be assigned an important role with respect to planning, implementation and monitoring of rural development programs. Some of the planning functions at the state level should be transferred to the district level planning units for effective decentralized district planning. A post of district development commissioner should be created. He should act as the chief executive officer of the Jila Parishad and should be in charge of all the development departments at the district level. Elections to the Panchayati Raj institutions should be held regularly. It found that elections become overdue for one or more tiers in 11 states. Thus, the committee, in its scheme of decentralized system of field administration, assigned a leading role to the Panchayati Raj in local planning and development. It is in this respect that the recommendation of the G.V.K. Rao committee report differed from those of the Dantwala committee report on block level planning and the Hanumanthari Rao committee report on district planning. Both the committees have suggested that the basic decentralized planning functions should be done at the district level. The Hanumanthari Rao committee advocated separate district planning bodies under either the district collector or a minister. In both the models, the collector should play a significant role in the decentralized planning, though the committee stated that Panchayati Raj institutions would also be associated with this process of decentralized planning. The committee recommended that the collector should be the coordinator at the district level of all developmental and planning activities. Thus, the Hanumanthari Rao committee differed in this respect from those of Balwant the Raik Mehta Committee, the Administrative Reforms Commission of India, the Ashok Mehta Committee, and finally the G.V.K. Rao Committee, which recommended reduction in the developmental role of the district collector and which assigned a major role to the Panchayati Raj in development administration. L.M. Singhvi Committee. In 1986, Rajiv Gandhi government appointed a committee to prepare a concept paper on revitalization of Panchayati Raj institutions for democracy and development under the chairmanship of L.M. Singhvi. It made the following recommendations. The Panchayati Raj institutions should be constitutionally recognized, protected and preserved. For this purpose, a new chapter should be added in the Constitution of India. This will make their identity and integrity reasonably and substantially inviolate. It also suggested constitutional provisions to ensure regular, free and fair elections to the Panchayati Raj bodies. Nai Panchayat should be established for a cluster of villages. The villages should be recognized to make Gram Panchayats more viable. It also emphasized the importance of the Gram Sabha and called it as the embodiment of direct democracy. The village Panchayat should have more financial resources. The judicial tribunal should be established in each state to adjudicate controversies about election to the Panchayati Raj institutions, their dissolution and other matters related to their functioning. Then Thungan Committee. In 1988, a subcommittee of the Consultative Committee of Parliament was constituted under the chairmanship of P.K. Thungan to examine the political and administrative structure in the district of for the purpose of district planning. This committee suggested for the strengthening of the Panchayati Raj system. It made the following recommendations. The Panchayati Raj bodies should be constitutionally recognized. A three-tier system of Panchayati Raj with panchayats at the village, block and district levels. Jila Parishad should be the pivot of the Panchayati Raj system. It should act as the planning and development agency in the district. The Panchayati Raj bodies should have a fixed tenure of 5 years. The maximum period of supersession of a body should be 6 months. A planning and coordination committee should be set up at the state level under the chairmanship of the Minister for Planning. The presidents of Jila Parishad should be its members. And a detailed list of subjects for Panchayati Raj should be prepared and incorporated in the constitution. A reservation of seats in all the three tiers should be on the basis of population. There should also be reservation for women. A state finance commission should be set up in each state. It would lay down the criteria and guidelines for the devolution of finances to the Panchayati Raj institutions. The district collector should be the chief executive officer of the Jila Parishad. Then Gadgil Committee. The Committee on Policy and Programs was constituted in 1988 by the Congress Party under the chairmanship of V.N. Gadgil. This committee was asked to consider the question of how best Panchayati Raj institutions could be made effective. In this context, the committee made the following recommendations. The constitutional status should be bestowed on the Panchayati Raj institutions. A three-tier system of Panchayati Raj with panchayats at the village, block and district levels. The term of Panchayati Raj institutions should be fixed at 5 years. The members of the panchayats at all the three levels should be directly elected. Reservation for SCs, STs and women. यहाँ पर डायरेक्ट इलेक्शन की बात किया जा रहा है कि ऑल द थ्री लेवल्स, बट पहले बात हुआ था इनडायरेक्ट इलेक्शन की, सिर्फ पंचायत लेवल में डायरेक्ट था, तो ये डिफरेंस था. द पंचायती राज बॉडीज शुड हैव द रेस्पॉन्सिबिलिटी of preparation and implementation of plans for socio-economic development. For this purpose, a list of subjects should be specified in the constitution. The Panchayat Raj body should be empowered to levy tax and collect and appropriate taxes and duties. Establishment of a state finance commission for the allocation of finances to the panchayats. Establishment of a state election commission for the conduction of elections to the panchayats. The above recommendations of the Gadgil committee became the basis for drafting an amendment bill aimed at conferring the constitutional status and protection to the Panchayat Raj institutions. Constitutionalization. Rajiv Gandhi government. The Rajiv Gandhi government introduced the 64 constitutional amendment bill in the Lok Sabha in July 1989 to constitutionalize Panchayati Raj institutions and make them more powerful and broad-based. Although the Lok Sabha passed the bill in August 1989, it was not approved by the Rajya Sabha. The bill was vehemently opposed by the opposition on the ground that it sought to strengthen centralization in the federal system. VP Singh government, the National Front government, soon after assuming office in November 1989 under the Prime Minister of VP Singh, announced that it would take steps to strengthen the Panchayati Raj institutions. In June 1990, a two-day conference of the state chief ministers under the chairmanship of VP Singh was held to discuss the issues relating to the strengthening of the Panchayati Raj body. The conference approved the proposals for the introduction of a fresh constitutional amendment bill. Consequently, a constitutional amendment bill was introduced in the Lok Sabha in September 1990. However, the fall of government resulted in the lapse of the bill. Narasimha Rao government, the Congress government under the Prime Minister of P.V. Narasimha Rao once again considered the matter of the constitutionalization of Panchayati Raj bodies. It drastically modified the proposals in this regard to delete the controversial aspects and introduced a constitutional amendment bill in the Lok Sabha in September 1991. This bill finally emerged as the 73rd Constitutional Amendment Act 1992 and came into force on 24 April 1993. तो यहाँ पर देखो स्टार्ट हो रहा है राजीव गांधी गवर्नमेंट से, जो कि था जब था 64th कॉन्स्टिट्यूशनल अमेंडमेंट, ठीक है। तो यहाँ पर राज्यसभा ने इसको अप्रूव नहीं किया था ये वाला बिल, तो फिर जाके 73rd में जाके ये फाइनली केम इनटू फोर्स होता है 1993 में। Okay, now 73rd Amendment Act of 1992. So significance of the act: this act has added a new part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provisions from articles 243 to 243O. In addition, the act has also added a new 11th schedule to the Constitution. This schedule contains 29 functional items of the Panchayats. It deals with article 243G. The act has given a practical shape to Article 40 of the Constitution, which says that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. This article forms a part of the directive principles of state policy. The act gives a constitutional status to the Panchayati Raj institutions. It has brought them under the purview of the justiciable part of the Constitution. In other words, the state governments are under constitutional application to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depend on the will of the state government anymore. The provisions of the Act can be grouped into two categories: compulsory and voluntary. The compulsory, mandatory or obligatory provisions of the Act have to be included in the state laws creating the new Panchayati Raj system. The voluntary provisions, on the other hand, may be included at the discretion of the states. Thus, the voluntary provisions of the Act ensures the right of the states to take local factors like geographical, political, administrative and others into consideration while adopting the new Panchayati Raj system. The Act is a significant landmark in the evolution of grassroots democratic institutions in the country. It transfers the representative democracy into participatory democracy. It is a revolutionary concept to build democracy at the grassroots level in the country. Saline features: the saline features of the Act are Gram Sabha. The Act provides for a Gram Sabha as the foundation of the Panchayati Raj system. It is a body consisting of persons registered in the electoral rolls of a village comprised within the area of Panchayat at the village level. Thus, it is a village assembly consisting of all the registered voters in the area of Panchayat. It may exercise such powers and perform such functions at the village level as the legislature of a state that determines. Three-tier system. The Act provides for a three-tier system of Panchayati Raj in every state, that is, panchayats at the village, intermediate and district level. Thus, the Act brings about uniformity in the structure of Panchayati Raj throughout the country. However, a state having a population not exceeding 20 lakh may not constitute panchayats at the intermediate level. Election of members and chairpersons. All the members of panchayats at the village, intermediate and district level shall be elected directly by the people. Further, the chairperson of panchayats at the intermediate and district level shall be elected indirectly by and from amongst the elected members thereof. However, the chairperson of a panchayat at the village level shall be elected in such manner as the state legislature determines. The chairperson of a panchayat and other members of a panchayat elected directly or indirectly shall have the right to vote in the meetings of the panchayats. Reservation of seats. The Act provides for the reservation of seats for scheduled caste and scheduled tribes in every panchayat, that is at all three levels. The at all three levels in proportion of their population to the total population in the panchayat areas. Further, the state legislature shall provide for the reservation of offices of chairperson in the panchayat at the village or any other level for the SCs and STs. The act provides for the reservation of not less than one third of the total number of seats for women, including the number of seats reserved for women belonging in the SCs and STs. Further, not less than one third of the total number of offices of chairpersons in the panchayats at each level shall be reserved for women. The act also authorizes the legislature of a state to make any provision for reservation of seats in any panchayat or offices of chairperson in the panchayat at any level in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the panchayats for the scheduled caste and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 70 years, that is till 2020. It must be noted here that the above provision relating to the reservation of seats in panchayats, both members and chairpersons for the scheduled caste, is not applicable to the state of Arunachal Pradesh. This is because the state is inhabited fully by indigenous tribal people and there are no scheduled castes. This provision was added later by the 83rd Constitutional Amendment Act of 2000. Duration of panchayats. The act provides for a 5-year term of office to the panchayat at every level. However, it can be dissolved before the completion of its term. Further, fresh elections to constitute a panchayat shall be completed before the expiry of its duration of 5 years or, in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But where the remainder of the period for which the dissolved panchayat would have continued is less than 6 months, it shall not be necessary to hold an election for constituting the new panchayats for such period. Moreover, a panchayat constituted upon the dissolution of a panchayat before the expiration of its duration shall continue only for the remainder of the period for which the dissolved panchayat would have continued had it not been so dissolved. In other words, a panchayat reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. Disqualifications. A person shall be disqualified for being chosen as or for being a member of panchayat if he is so disqualified under any law for the time being in force for the purpose of elections to the legislature of the state concerned or under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. So 21 years हो गया तो इसमें इस इलेक्शन में भाग ले सकते हैं. Further, all questions of disqualification shall be referred to such authority as the state legislature determines. State Election Commission. The superintendence, direction and control of the preparation of electoral rolls and the conduct of all elections to the panchayat shall be vested in the State Election Commission. It consists of a state election commissioner to be appointed by the governor. His conditions of service and tenure of office shall also be determined by the governor. He shall not be removed from the office except in the manner and on the grounds prescribed for the removal of a judge of the state high court. His conditions of service shall not be varied to his disadvantage after his appointment. The state legislature may make provision with respect to all members relating to elections to the panchayats. Powers and functions. The state legislature may endow the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon panchayats at the appropriate level with respect to the preparation of plans for economic development and social justice, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 29 matters listed in the 11th schedule. Finances. The state legislature may authorize a panchayat to levy, collect and appropriate taxes, duties, tolls and fees assigned to a panchayat, taxes, duties, tolls and fees levied and collected by the state government, provide for making grants in aid to the panchayats from the consolidated fund of the state and provide for constitution of funds for crediting all monies of the panchayats. Finance Commission. The governor of a state shall after every 5 years constitute a finance commission to review the financial position of the panchayats. It shall make the following recommendations to the governor: the principles that should govern the distribution between the state and the panchayats of the net proceeds of the taxes, duties, tolls and fees levied by the state and allocation of shares amongst the panchayats at all levels, the determination of taxes, duties, tolls and fees that may be assigned to the panchayats, the grants in aid to the panchayats from the consolidated fund of the state, the measures needed to improve the financial position of the panchayats, any other matter referred to it by the governor in the interest of sound finance of the Panchayats. The state legislature may provide for the composition of the commission, the required qualifications of its members, and the manner of their selection. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats in the states on the basis of the recommendations made by the finance commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by the panchayats and the auditing of such accounts. Application to union territories. The provisions of this part are applicable to the union territories, but the president may direct that they would apply to a union territory subject to such exceptions and modifications as he may specify. Exempted states and areas. The act does not apply to the states of Nagaland, Meghalaya and Mizoram and certain other areas. These areas include the scheduled areas and tribal areas in the states, the hill areas of Manipur for which district council exists, and Darjeeling district of West Bengal for which Darjeeling Gorkha Hill Council exists. तो यहाँ पर पंचायत राज नहीं है. However, the parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. Under this provision, the parliament has enacted the provisions of the Panchayats Extension to the Scheduled Areas Act 1996, popularly known as the PESA Act or the Extension Act. Continuance of existing laws and panchayats. All the state laws relating to panchayats shall continue to be in force until the expiry of 1 year from the commencement of this act. In other words, the states have to adopt the new Panchayat Raj system based on this act within the maximum period of 1 year from 24 April 1993, which was the date of the commencement of this act. However, all the panchayats existing immediately before the commencement of act shall continue till the expiry of their term unless dissolved by the state legislature sooner. Consequently, majority of states passed the Panchayati Raj Acts in 1993 and 1994 to adopt the new system in accordance with the 73rd Constitutional Amendment Act of 1992. Bar to interference by courts in electoral matters. The act bars the interference by courts in the electoral matters of panchayats. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned at any court. It further lays down that no election to any panchayat is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislatures. 11th schedule. It contains the following 29 functional items placed within the purview of panchayats: agriculture, including agricultural extension, land improvement, implementation of land reform, land consolidation and soil conservation, minor irrigation, water management and watershed development, animal husbandry, dairying and poultry, fisheries, social forestry and farm forestry, minor forest produce, small scale industries including food processing industries, khadi, village and cottage industries, rural housing, drinking water, fuel and fodder, roads, culverts, bridges, ferries, waterways and other means of communication, rural electrification including distribution of electricity, non-conventional energy sources, poverty alleviation program, education including primary and secondary schools, technical training and vocational education, adult and non-formal education, libraries, cultural activities, markets and fairs, health and sanitation including hospitals, primary health centers and dispensaries, family welfare, women and child development, social welfare including welfare of the handicapped and mentally retarded, then welfare of the weaker sections and in particular of the scheduled caste and the scheduled tribes, public distribution system, maintenance of community assets. Compulsory and voluntary provisions. Now we will identify separately the compulsory, obligatory or mandatory and voluntary, discretionary or optional provisions, features of the 73rd Constitutional Amendment Act 1992 or the Part 9 of the Constitution. Compulsory provisions: organization of Gram Sabha in a village or group of villages, establishment of panchayats at the village, intermediate and district levels, direct elections to all seats in panchayats at all the village, intermediate and district levels, indirect elections to the post of chairperson of panchayats at the intermediate and district levels, voting rights of the chairperson and other members of a panchayat elected directly or indirectly, 21 years to be the minimum age for contesting elections to panchayats, reservation of seats both members and chairpersons for SCs and STs in panchayats at all the three levels, reservation of 1/3 seats both members and chairpersons for women in panchayats at all the three levels, fixing tenure of 5 years for panchayats at all levels and holding fresh elections within 6 months in the event of suppression of any panchayat, establishment of a state election commission for conducting elections to the panchayats, constitution of a state finance commission after every 5 years to review the financial position of the panchayats, Voluntary provisions endowing the Gram Sabha with powers and functions at the village level, determining the manner of election of the chairperson of the village panchayat, giving representation to the chairpersons of the village panchayats in the intermediate panchayats, or in the case of a state not having intermediate panchayats, in the district panchayats, giving representation to the chairpersons of the intermediate panchayats in the district panchayats, giving representation to members of the parliament, both the houses and the state legislature, both the houses in the panchayats at different levels falling within their constituencies, providing reservation of seats both members and chairpersons for backward classes in panchayats at any level, granting powers and authority to the panchayats to enable them to function as institutions of self-government, in brief, making them autonomous bodies. Devolution of powers and responsibilities upon panchayats to prepare plans for economic development and social justice, and to perform some or all of the 29 functions listed in the 11th schedule of the constitution. Granting financial powers to the panchayats, that is, authorizing them to levy, collect, and appropriate taxes, duties, tolls and fees, assigning to a panchayat the taxes, duties, tolls and fees levied and collected by the state government, making the grants in aid to the panchayats from the consolidated fund of the state, providing for constitution of funds for crediting all monies of the panchayats. Then PESA Act of 1996 Extension Act. The provisions of Part 9 of the Constitution relating to the panchayats are not applicable to the 5th scheduled areas. However, the Parliament may extend these provisions to such areas, subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats Extension to the Scheduled Areas Act 1996, popularly known as PISA Act or Extension Act. At present, 2019, 10 states have 5th scheduled areas. These are Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. All the 10 states have enacted requisite compliance legislations by amending the respective Panchayati Raj Acts. Objectives of the Act. The objectives of the PISA Act are as follows. To extend the provisions of Part 9 of the Constitution relating to the panchayats to the scheduled areas with certain modifications, to provide self-rule for the bulk of the tribal population, to have village governance with participatory democracy, and to make the Gram Sabha a nucleus of all activities, to evolve a suitable administrative framework consistent with the traditional practices, to safeguard and to preserve the traditions and customs of tribal communities, to empower panchayats at the appropriate levels with specific powers conducive to tribal requirements, to prevent panchayats at the higher level from assuming the powers and authority of panchayats at the lower level of the Gram Sabha. Features of the Act. The features of the provisions of the PISA Act are as follows. State legislation on the panchayats in the scheduled areas shall be in consonance with the customary law, social and religious practices, and traditional management practices of community resources. A village shall ordinarily consist of a habitation or a group of habitations, or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with traditions and customs. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the panchayat at the village level. Every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources, and the customary mode of dispute resolution. Every Gram Sabha shall approve of the plans, programs, and projects for social economic development before they are taken up implementation by the panchayat at the village level, and be responsible for the identification of beneficiaries under poverty alleviation and other programs. Every panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs and projects. The reservation of seats in the scheduled areas in every panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than one half of the total number of seats. Further, all seats of chairpersons of panchayats at all levels shall be reserved for the scheduled tribes. The state government may nominate such scheduled tribes which have no representation in the panchayat at the intermediate level or the panchayat at the district level, but such nominations shall not exceed 1/10 of the total members to be elected in the panchayat. In that panchayat, the Gram Sabha or the panchayats at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects, and before resettling or rehabilitating persons affected by such projects in the scheduled areas. However, the actual planning and implementation of the projects in the scheduled areas shall be coordinated in the state level. Planning and management of minor water bodies in the scheduled areas shall be entrusted to panchayats at the appropriate level. The recommendations of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of prospecting license and mining lease for minor minerals in the scheduled areas. The prior recommendation of the Gram Sabha or the Panchayats at the appropriate level shall be mandatory for a grant of concession for the exploitation of minor minerals by auction. While endowing panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, state legislatures shall ensure that the panchayats at the appropriate level and the Gram Sabha are endowed specifically with the power to enforce prohibition or to regulate or restrict the इसमें and consumption of any intoxicant, the ownership of minor forest produce, the power to prevent alienation of land in the scheduled areas and to take appropriate action to restore any unlawfully alienation of land of scheduled tribe, the power to manage village markets, the power to exercise control over money lending to scheduled tribes, the power to exercise control over institutions and functionaries at all social sectors, the power to control local plans and resources for such plan, including tribal sub-plans. The state legislation shall contain safeguards to ensure that the panchayats at the higher level do not assume the powers and authority of any panchayat at the lower level or the Gram Sabha. The state legislature shall endeavour to follow the pattern of the 6th schedule to the constitution while designing the administrative arrangements in the panchayats at district levels in the scheduled areas. Any provision of any law relating to panchayats in the scheduled areas which is inconsistent with the provisions of this act shall cease to be in force at the expiry of 1 year from the date on which this act receives the assent of the President. However, all the panchayats existing immediately before such date shall continue till the expiry of their term unless dissolved by the state legislature sooner. Finances of Panchayati Raj. The second Administrative Reforms Commission of India 2005-9 has summarized the resources of revenue of the Panchayati Raj institutions and their financial problems in the following way. A major portion of Part 9 of the Constitution deals with structural empowerment of the PRIs, but the real strength in terms of both autonomy and efficiency of these institutions is dependent on their financial position, including their capacity to generate own resources. In general, panchayats in our country receive funds in the following ways: grants from the Union government based on recommendations of the Central Finance Commission as Article 280 of the Constitution, devolution from the state government based on recommendations of the State Finance Commission as per Article 243I, loans or grants from the state government, program specific allocation under centrally sponsored schemes and additional central assistance, internal resource generation, tax and non-tax. Across the country, states have not given adequate attention to fiscal empowerment of the panchayats. The panchayats' own resources are meager. Kerala, Karnataka and Tamil Nadu are the states which are considered to be progressive in PRI's empowerment, but even there, the panchayats are heavily dependent on government grants. One can draw the following broad conclusions. Internal resource generation at the panchayat level is weak. It's partly due to a thin tax domain and partly due to panchayat own reluctance in collecting revenue. Panchayats are heavily dependent on grants from union state governments. A major portion of the grants, both from union as well as the state governments, is scheme specific. Panchayats have limited discretion and flexibility in incurring expenditure. In view of their own tight fiscal position, state governments cannot keen to develop funds to panchayats in most of the critical 11 scheduled matters like primary education, healthcare, water supply, sanitation and micro irrigation. Even now, it is the state government which is directly responsible for implementation of these programs and the expenditure. Overall, a situation has been created where panchayats has responsibility but grossly inadequate resources. Though in absolute terms, the quantum of funds the union or state government transfers to a panchayat forms the major component of its receipt, the PRI's own resource generation is the soul behind its financial standing. It is not only a question of resources, it is the existence of a local taxation system which ensures people's involvement in the affairs of an elected body. It also makes the institution accountable to its citizens in terms of own resource collection. The Gram Panchayats are comparatively in a better position because they have a tax domain of their own, while the other two tiers are dependent only on tolls, fees and non-tax revenue for generating internal resources. State Panchayati Raj Acts have given most of the taxation powers to village panchayats. The revenue domain of the intermediate and district panchayats, both tax as well as non-tax, has been kept much smaller and remains confined to secondary areas like ferry services, markets, water and Conservancy services, registration of vehicles, cess on stamp duty, and a few others. A study of various state legislations indicates that a number of taxes, duties, tolls, and fees come under the jurisdiction of the village panchayats. These inter alia include octroi, property, house tax, profession tax, land tax, taxes, tolls on vehicles, entertainment and tax, fees, license fees, tax on non-agricultural land, fee on registration of cattle, sanitation, drainage, conservancy tax, water rate tax, lighting tax, education cess and tax, submit tax on fairs and festivals. Now, reasons for ineffective performance. Even after conferring the constitutional status and protection through the 73rd Amendment Act 1992, the performance of the Panchayati Raj institutions has not been satisfactory and not up to the expected level. The various reasons for this suboptimal performance are as follows. Lack of adequate devolution. Many states have not taken adequate steps to devolve 3Fs, functions, funds and functionaries to the FERH to enable them to discharge their constitutionally stipulated function. Further, it is imperative that the PRH have resources to match the responsibilities entrusted to them. While SFC's test finance commissions have submitted their recommendations, not many few states have implemented these or taken steps to ensure the fiscal viability of the PRH. Excessive control by bureaucracy. In some states, the Gram Panchayats have been placed in a position of subordination. Hence, the Gram Panchayats Sarpanches have to spend extraordinary amount of time visiting block offices for funds and or technical approval. These interactions with block staff office distort the role of Sarpanch as elected representatives. Tied nature of funds. This has two implications. The activities stated under a certain scheme are not always appropriate for all parts of the district. This results in unsuitable activities being promoted or an underspend of the funds. Overwhelming dependency on government funding. A review of money received and own source funds shows the overwhelming dependence of panchayats on government funding. When panchayats do not raise resources and instead receive funds from outside, people are less likely to request a social audit. Reluctance to use fiscal powers. An important power developed to GP Gram Panchayats is the right to levy tax on property, business, market shares, and also for services provided like street lighting or public toilets, etc. Very few panchayats use their fiscal power to levy and collect taxes. The argument pushed by panchayat heads is that it is difficult to levy tax on your own constituency, especially when you live in the community. ये भी सच बात है. Status of the Gram Sabha. Empowering the Gram Sabha could have been a powerful weapon for transparency, accountability, and for involvement of the marginalized sections. However, a number of the state acts have not spelled the powers of Gram Sabha, nor have any procedures been laid down for the functioning of these bodies or penalties for the officials. Creation of parallel bodies. Often, parallel bodies are created for supposedly speedy implementation and greater accountability. However, there is little evidence to show that such PBs have avoided the evils, including that of partisan politics, sharing of spoils, corruption, and elite capture missions, in particular, often bypassing mainstream programs, create disconnect, duality, and alienation between the existing and the new structures and functions. PBs usurp the legitimate space of PRH and demoralize the PRH by virtue of their superior resource endowments. Then poor infrastructure. A large number of Gram Panchayats in the country do not have even full-time secretary. Around 25% of the Gram Panchayats do not have basic office buildings. The database for planning, monitoring, etc. lacking in most of the cases. A large number of elected representatives of PRH are semi-literate or literate and know little about their roles and responsibilities. Programs, procedures, systems, often for want of good, relevant and periodic training, they are not able to perform their functions properly. Although all the district and intermediate panchayats are connected with computers, only around 20% Gram Panchayats reported to be having computing facility. In some states, village panchayats do not have any computing facility. ठीक है, ये चैप्टर खत्म होता है. यहाँ पर देखो दिया गया है आर्टिकल नंबर एंड देयर सब्जेक्ट मैटर लिस्ट है. नेम ऑफ पंचायत राज इंस्टीट्यूशन इन द स्टेट्स. तो यहाँ पर देखो 3 लेवल्स है, तो उनमें नेम अलग अलग है. जैसे कि आंध्र प्रदेश में देखो सेकंड नंबर पे मंडल परिषद, उसको अरुणाचल प्रदेश में उसको बोलते हैं अंचल समिति. ठीक है, वेस्ट बंगाल का क्या है देख लेते हैं एक बार. ग्राम पंचायत, देन पंचायत समिति एंड देन जिला परिषद. यहाँ पर तीन है प्रेजेंटली. पहले 4 हमने पढ़ा कि पहले 4 टायर डेवलप किया था, बट प्रेजेंटली इसमें 3 ही है. ठीक है, टुवर्ड्स फर्स्ट जनरेशन पंचायत. तो ये हिस्ट्री दिया गया है, टाइमलाइन एक दिखाया गया है इसमें. ये देखो 1993, तो ये होता है ये वाला. फिर कब का क्या चेंजेस हुआ उसके बारे में दिखाया गया है. और ये सारे कमिटीज़ है ना, कमिटीज रिलेटेड टू पंचायती राज यहाँ पर दिया गया है. अब नेक्स्ट चैप्टर है म्यूनिसिपैलिटीज़ के बारे में, तो ये चैप्टर 39 है, ये म्यूनिसिपैलिटीज अर्बन एरियाज के लिए। द टर्म अर्बन लोकल गवर्नमेंट इन इंडिया signifies the governance of an urban area by the people through their elected representatives. The jurisdiction of an urban local government is limited to a specific urban area which is demarcated for this purpose by the state government. There are 8 types of urban local governments in India: municipal corporation, municipality, notified area committee, town area committee, cantonment board, township, port trust and special purpose agency. तो ये वाला पीएचडी के इंटरव्यू में एक बार पूछा था कि क्या डिफरेंस है म्यूनिसिपैलिटी, म्यूनिसिपल कॉरपोरेशन, नोटिफाइड एरिया कमेटी। मैंने तीनों के बारे में पूछा था मेरे को, जाहिर सी बात मेरे को नहीं आया था क्योंकि ये सब मैंने पहले नहीं पढ़ा था तब। तो देखो 8 टाइप्स ऑफ अर्बन लोकल गवर्नमेंट एक्चुअल में है, वो क्या क्या है वो हमने देखा। द सिस्टम ऑफ अर्बन गवर्नमेंट वाज constitutionalized through the 74th Constitutional Amendment Act of 1992 at the central level. The subject of urban local government is dealt with by the following 3 ministries: Ministry of Housing and Urban Affairs, Ministry of Defence in case of cantonment boards, Ministry of Home Affairs in case of union territories. Then evolution of urban bodies, historical perspective. The institutions of urban local government originated and developed in modern India during the period of British rule. The major events in this context are as follows. In 1688, the first municipal corporation in India was set up at Madras. In 1726, the municipal corporations were set up in Bombay and Calcutta. Lord Mayo's resolution in 1870 on financial decentralization visualized the development of local self-government institutions. Lord Ripon's resolution of 1882 has been held as the Magna Carta of local self-government. He is called the father of local self-government. Lord Ripon को father of local self-government बोला जाता है. The Royal Commission on Decentralization was appointed in 1907 and it submitted its report in 1909. Its chairman was Hobhouse. कैसा नाम है भाई. अंडर द डायरकिकल स्कीम इंट्रोड्यूस्ड इन प्रोविंसेज बाय द गवर्नमेंट ऑफ इंडिया एक्ट ऑफ 1919, लोकल सेल्फ गवर्नमेंट became a transferred subject under the charge of a responsible Indian minister. In 1924, the Cantonments Act was passed by the central legislature. Under the provincial autonomy scheme introduced by the government of India Act of 1935, local self government was declared a provincial subject. Committees and commissions, तो इसका लिस्ट दिया गया नीचे. Constitutionalization. In August 1989, the Rajiv Gandhi government introduced the 65th Constitutional Amendment Bill, that is Nagarpalika Bill, in the Lok Sabha. The bill aimed at strengthening and revamping the municipal bodies by conferring a constitutional status on them. Although the bill was passed in the Lok Sabha, it was defeated in the Rajya Sabha in October 1989 and hence lapsed. However, the bill was not passed and finally lapsed due to the dissolution of the Lok Sabha. P.V. Narasimha Rao's government also introduced the modified municipalities bill in the Lok Sabha in September 1991. It finally emerged as the 74th Constitutional Amendment Act of 1992 and came into force on 1 June 1993. तो वो था ये अप्रैल में, ये जून में. द 74th अमेंडमेंट, वो मतलब 73rd अमेंडमेंट, आई मीन पंचायती राज. 74th अमेंडमेंट एक्ट ऑफ 1992. The act has added a new part 9A to the Constitution of India. This part is entitled as the Municipalities and consists of provisions from Article 243P to 243ZG, है ना. तो वहाँ पर था O तक, 243 से लेकर 243O, और उसके बाद O के बाद P आता है, तो 243P से 243ZG तक है हमारा म्यूनिसिपैलिटी, जो कि पार्ट 9A है. In addition, the act has also added a new 12th schedule to the constitution. This schedule contains 18 functional items of municipalities. It deals with Article 243W. The act gave constitutional status to the municipalities. It has brought them under the purview of justiciable part of the constitution. In other words, state governments are under constitutional obligation to adopt the new system of municipalities in accordance with the provisions of the act. The act aims at revitalizing and strengthening the urban government so that they function effectively as units of local government. Salient features. 3 types of municipalities. The act provides for the constitution of the following 3 types of municipalities in every state: a Nagar Panchayat, by whatever name called, for a transitional area; a municipal council for a smaller urban area; and municipal corporation for a larger urban area. But there is one exception: if there is an urban area. तो हमने वहाँ पर देखा कि 8 टाइप का था ना, तो वो एक्चुअल में ये जो कॉन्स्टिट्यूशनल है वो वहाँ पर तीनों ही टाइप का 3 लेवल्स का मेंशन किया है. जैसे कि देखो यहाँ पर 8 टाइप्स ऑफ अर्बन लोकल गवर्नमेंट्स इन इंडिया, है ना. नहीं, 8 टाइप के तो है इंडिया में, बट ये क्या है फिर 3 कैटेगरी में बांट दिया गया क्या, ऐसा देखते पढ़ते हैं। तो यहाँ पर देखो एक है नगर पंचायत, देन म्यूनिसिपल काउंसिल एंड म्यूनिसिपल कॉर्पोरेशन, बट देयर इज वन एक्सेप्शन इफ देयर इज एन अर्बन एरिया वेयर म्यूनिसिपल सर्विसेज आर बीइंग प्रोवाइडेड बाय एन इंडस्ट्रियल एस्टेब्लिशमेंट, देन द गवर्नर may specify that area to be an industrial township. In such a case, a municipality may not be constituted. The governor has to specify a transitional area, a smaller urban area or a larger urban area, keeping in view the following factors: population of the density of the population therein, revenue generated for local administration, percentage of employment in non-agricultural activities, economic importance, such other factors as he may deem it. Composition. So composition: all the members of a municipality shall be elected directly by the people of the municipal area. For this purpose, each municipal area shall be divided into territorial constituencies to be known as wards. The state legislature may provide the manner of election of the chairperson of a municipality. It may also provide for the representation of the following persons in a municipality: persons having special knowledge or experience in municipal administration without the right to vote in the meetings of municipality, the members of the Lok Sabha and the state legislative assembly representing constituencies that comprise wholly or partly the municipal area, the members of the Rajya Sabha and the state legislative council registered as electors within the municipal area, the chairpersons of committees other than ward committees. Ward committees: there shall be constituted a ward committee consisting of one or more wards within the territorial area of a municipality having population of 3 lakh or more. The state legislature may make provision with respect to the composition and the territorial area of a wards committee and the manner in which the seats in a wards committee shall be filled. Other committees: in addition to the wards committee, the state legislature is also allowed to make any provision for the constitution of other committees. The chairpersons of such committees may be made members of the municipality. Reservation of seats: the act provides for the reservation of seats for the scheduled castes and the scheduled tribes in every municipality in proportion of their population to the total population in the municipal area. Further, it provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SCs and the STs. The state legislature may provide for the manner of reservation of offices of chairpersons in the municipalities for SCs, STs and women. It may also make any provision for the reservation of seats in any municipality or offices of chairpersons in municipalities in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the municipalities for the scheduled caste and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 70 years, that is till 2020. Duration of municipalities: the act provides for a 5-year term. तो इसमें अपडेट आपको लेना है कि मेरे को भी देखना पड़ेगा कि 2020 तक था, तो अभी तो 2024 चल रहा है, क्या हुआ इसका. ड्यूरेशन ऑफ म्यूनिसिपैलिटी: द एक्ट प्रोवाइड्स फॉर ए 5-year term of office for every municipality. However, it can be dissolved before the completion of its term. Further, the fresh elections to constitute a municipality shall be completed before the expiry of its duration of 5 years, or in case of dissolution before the expiry of a period of 6 months from the date of its dissolution. But where the remainder of the period for which the dissolved municipality would have continued is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality for such period. Moreover, a municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued had it not been so dissolved. In other words, a municipality reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. The Act also makes 2 more provisions with respect to dissolution. A municipality must be given a reasonable opportunity of being heard before its dissolution, and no amendment of any law for the time being in force shall cause dissolution of a municipality before the expiry of the 5 years term. Disqualification: a person shall be disqualified for being chosen. वही सेम बात है जैसे ग्राम सभा में था. चलो, स्टेट इलेक्शन कमीशन: द सुपरिंटेंडेंट डायरेक्शन एंड कंट्रोल ऑफ द प्रिपरेशन ऑफ इलेक्टोरल रूल्स एंड द कंडक्ट ऑफ ऑल इलेक्शंस टू द म्यूनिसिपैलिटीज shall be vested in the state election commission. The state legislature may make provision with respect to all matters relating to elections to the municipalities. Powers and functions: the state legislature may endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon municipalities at the appropriate level with respect to the preparation of plans for economic development and social justice, the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 18 matters listed in the 12th schedule. Finances. The state legislature may authorize a municipality to levy, collect and appropriate taxes, duties, tolls, fees assigned to a municipality. Taxes, duties, tolls and fees levied and collected by state government, provide for making grants in aid to the municipality from the consolidated fund of the state, and provide for constitution of funds for crediting all monies of the municipalities. Finance Commission. The Finance Commission, which is constituted for the panchayats, shall also for every 5 years review the financial position of municipalities and make recommendation to the governor as to the principles that should govern the distribution between the state and municipalities of the net proceeds of the taxes, duties, tolls and fees levied by the state, and the allocation of shares amongst the municipalities at all levels, the determination of the taxes, duties, tolls and fees that may be assigned to the municipalities, the grants in aid to the municipalities from the consolidated fund of the state, the measures needed to improve the financial position of the municipalities, any other matter referred to it by the governor in the interest of sound finance of municipality. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the municipalities in the state on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by municipalities and the auditing of such accounts. Application of union territories. The provisions of this part are applicable to the union territories, but the president may direct that they would apply to a union territory, subject to such exceptions and modifications as he may specify. Exempted areas. The Act does not apply to the scheduled areas and tribal areas in the states. It shall also not affect the functions and powers of the Darjeeling Gorkha Hill Council of the West Bengal. However, the Parliament may extend the provisions of this part to scheduled areas and tribal areas, subject to such exceptions and modifications as it may specify. District Planning Committee. Every state shall constitute at the district level a district planning committee to consolidate the plans prepared by panchayats and municipalities in the district and to prepare a draft development plan for the district as a whole. The state legislature may make provisions with respect to the following: the composition of such committees, the manner of election of members of such committees, the functions of such committees in relation to district planning, and the manner of the election of the chairpersons of such committees. The Act lays down that 4/5 of the members of a district planning committee should be elected by the elected members of the district panchayat and municipalities in the district from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the rural and urban populations in the district. The chairperson of such committee shall forward the development plan to the state government. In preparing the draft development plan, a district planning committee shall have regard to matters of common interest between the panchayats and municipalities, including spatial planning, sharing of water, other physical and natural resources, the integrated development of infrastructure and environmental conservation, the extent and type of available resources, whether financial or otherwise, and consult such institutions and organizations as the governor may specify. Then Metropolitan Planning Committee. Every metropolitan area shall have a metropolitan planning committee to prepare a draft development plan. The state legislature may make provisions with respect to the following: the composition of such committees, the manner of election of members of such committees, the representation in such committees of the central government, state government and other organizations, the functions of such committees in relation to planning and coordination for the metropolitan area, and the manner of election of chairpersons of such committees. The Act lays down that 2/3 of the members of a metropolitan planning committee should be elected by the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the population of the municipalities and the panchayats in that metropolitan area. The chairpersons of such committees shall forward the development plan to the state government. In preparing the draft development plan, a metropolitan planning committee shall have regard to the plans prepared by the municipalities and panchayats, the metropolitan area, matters of common interest between the municipalities and the panchayats, including coordinated special planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation, the overall objectives and priorities set by the government of India and the government of the state, the extent and nature of investments like to be made in the metropolitan area by agencies of the government of India and the government of the state, and the other available resources, whether financial or otherwise, and consult such institutions and organizations as the governor may specify. बाप रे, चलिए थोड़ा और पेजेस से कंप्लीट कर लेंगे अभी। एक बार जस्ट पढ़ लेते हैं तो, और 10 पेजेस है लगभग। एक बार पॉज करते हैं, बहुत गर्मी लग रही है। Then continuance of existing laws and municipalities. So all the state laws relating to municipalities shall continue to be in force until the expiry of 1 year from the commencement of this act. In other words, the states have to adopt the new system. वही सेम बात है पंचायत राज की तरह. चलो हटाओ इसको. बार टू इंटरफेरेंस ऑफ बाई कोर्ट्स इन इलेक्ट्रल मैटर्स. द एक्ट बार्स द इंटरफेरेंस बाई कोर्ट्स. सेम चीज़ है कि कोई कोर्ट में नहीं जा सकती इसके ऊपर. जो भी इलेक्शन होगा जो भी होगा इसको लेकर. 12th शेड्यूल में क्या क्या है? 18 फंक्शनल आइटम्स है प्लेस्ड इन द परव्यू ऑफ म्यूनिसिपैलिटीज. तो प्लानिंग है, रेगुलेशन है, प्लानिंग ऑफ इकोनॉमिक सोशल डेवलपमेंट है, रोड्स है, वाटर सप्लाई है, जैसे रेगुलेशन ऑफ स्लॉटर हाउसेज एंड टैनरीज पब्लिक एमिनिटीज इंक्लूडिंग स्ट्रीट लाइटिंग. तो वही सेम है. चलो इसको हटाओ. 18 आइटम्स यहाँ पर है. जितना याद रखना है, ठीक है. और पंचायती राज में कितना था एग्जैक्ट नंबर याद है तो बताओ कमेंट में. देखो अब ये इंटरेस्टिंग टॉपिक आ रहा है. टाइप्स ऑफ अर्बन गवर्नमेंट्स. तो फॉलोइंग 8 टाइप्स जैसे कि हमने पहले पढ़ा, तो एक एक करके देखते. देखो म्यूनिसिपल कॉर्पोरेशन. म्यूनिसिपल कॉर्पोरेशंस आर क्रिएटेड फॉर द एडमिनिस्ट्रेशन ऑफ बिग सिटीज लाइक दिल्ली, मुंबई. तो म्यूनिसिपल कॉर्पोरेशन सबसे ऊपर है क्या? यस, म्यूनिसिपल कॉर्पोरेशन फिर सबसे ऊपर होगा क्योंकि बिल्कुल बिग सिटीज़ के लिए, जैसे दिल्ली, मुंबई, इसके बारे तो कोई हो नहीं सकता है नहीं अभी. Okay, so they are established in the states by the acts of the concerned states legislatures and in the union territories by the acts of the Parliament of India. There may be one common act for all the municipal corporations in a state or a separate act for each municipal corporation. A municipal corporation has 3 authorities, namely the council, the standing committee and the commissioner. The council is the deliberative and legislative wing of the corporation. It consists of the councillors directly elected by the people, as well as a few nominated persons having knowledge or experience of municipal administration. In brief, the composition of the council, including the reservation of seats for SCs, STs and women, is governed by the 74th Constitutional Amendment Act. The council is headed by a mayor. He is assisted by a deputy mayor. He is elected in majority of the states for a 1-year renewable term. He is basically an ornamental figure and a formal head of the corporation. His main function is to preside over the meetings of the council. The standing committees are created to facilitate the working of the council, which is too large in size. They deal with public works, education, health, taxes and finance and so on. They take decisions in their fields. Then the municipal commissioner is responsible for the implementation of the decision taken by the council and its standing committee. Thus he is the chief executive authority of the corporation. तो इसको म्यूनिसिपल कमिश्नर बोला जाता है. ही इज अपॉइंटेड बाय द स्टेट गवर्नमेंट एंड इज जनरली अ मेंबर ऑफ द IAS. ठीक है, स्टेट गवर्नमेंट के द्वारा नियुक्त किया जाता है, बट जनरली मेंबर ऑफ IAS. आई में इंडियन एडमिनिस्ट्रेटिव सर्विस यही पूछेंगे, बट मेंबर क्यों बोल रहा है फिर? ये ऑफिसर बोलना चाहिए था, पता नहीं. देखते हैं आगे. म्यूनिसिपैलिटी. द म्यूनिसिपैलिटीज आर एस्टेब्लिश्ड फॉर द एडमिनिस्ट्रेशन ऑफ टाउन्स एंड smaller cities like the corporations. They are also set up in the states by the acts of the concerned state legislatures and in तो ये स्मॉलर सिटीज़ के लिए है म्यूनिसिपैलिटी. ठीक है, पहली बात ये. दे आर ऑल्सो नोन बाय वेरियस अदर नेम्स लाइक म्यूनिसिपल काउंसिल, म्यूनिसिपल कमिटी, म्यूनिसिपल बोर्ड, बॉरो म्यूनिसिपैलिटी, सिटी म्यूनिसिपैलिटी एंड अदर्स. इसका बहुत सारे नेम है म्यूनिसिपैलिटी का. लाइक अ म्यूनिसिपल कॉर्पोरेशन, ए म्यूनिसिपैलिटी ऑल्सो हैज 3 अथॉरिटीज, नेमली काउंसिल, स्टैंडिंग कमिटी एंड चीफ एग्जीक्यूटिव ऑफिसर. द काउंसिल इज द डेलिबरेटिव एंड लेजिस्लेटिव विंग. तो सेम ही होगा, वही रोल है. द काउंसिल इज हेडेड बाय प्रेसिडेंट और चेयरमैन. ही इज असिस्टेड बाय वाइस प्रेसिडेंट और वाइस चेयरमैन. ही प्रिसाइड्स ओवर द मीटिंग्स ऑफ द काउंसिल. अनलाइक द मेयर ऑफ म्यूनिसिपल कॉर्पोरेशन, ही प्लेज अ सिग्निफिकेंट रोल एंड इज द पाइवट ऑफ द म्यूनिसिपल एडमिनिस्ट्रेशन. अपार्ट फ्रॉम प्रिसाइडिंग ओवर द मीटिंग्स ऑफ काउंसिल, ही एंजॉयज एग्जीक्यूटिव पावर्स. बट यहाँ का इसके एग्जीक्यूटिव पावर्स भी है. ठीक है, जो काउंसिल होगा, सॉरी प्रेसिडेंट या चेयरमैन होगा. द स्टैंडिंग कमिटी आर क्रिएटेड टू फैसिलिटेट द वर्किंग ऑफ द काउंसिल. दे डील विद पब्लिक वर्क्स, टैक्सेशन, हेल्थ, फाइनेंस एंड सो ऑन. द चीफ एग्जीक्यूटिव ऑफिसर और चीफ म्यूनिसिपल ऑफिसर इज रेस्पॉन्सिबल फॉर डे टू डे जनरल एडमिनिस्ट्रेशन ऑफ द म्यूनिसिपैलिटी. ही इज अपॉइंटेड बाय द स्टेट गवर्नमेंट. Now, notified area committee. A notified area committee is created for the administration of 2 types of areas: a fast developing town due to industrialization and a town which does not yet fulfill all the conditions necessary for the constitution of a municipality, but which otherwise is considered important by the state government. Since it is established by notification in the government gazette, it is called a notified area committee, though it functions within the framework of the state Municipal Act, only those provisions of the Act apply to it which are notified in the Government Gazette by which it is created. It may also be interested to exercise powers under any other act. Its powers are almost equivalent to those of a municipality, but unlike the municipality, it is an entirely nominated body. That is, all the members of a notified area committee, including the chairman, are nominated by the state government. Thus, it is neither an elected body nor a statutory body. Then town area committee. A town area committee is set up for the administration of a small town. It is a semi-municipal authority and is entrusted with a limited number of civic functions like drainage, road, street lighting and conservancy. It is created by a separate act of a state legislature. Its composition, functions and other matters are governed by the act. It may be wholly elected or wholly nominated by the state government, or partly elected and partly nominated. Then cantonment board. So cantonment board is established for municipal administration of civilian population in the cantonment area. It is set up. तो देखो इसे हायरार्की नहीं है कोई, बट ये जो थ्री है, फर्स्ट थ्री जो है ये हायरार्की है. तो हर किसी एरिया को, वो जो क्वेश्चन मैंने बात किया कि एक गया था इंटरव्यू में, तो वहाँ पर सर ने मेरे को फिर बता दिया आंसर क्या है. तो उन्होंने बताया था कि हर एक एरिया पहले नोटिफाइड एरिया कमेटी बनेगा, फिर उसके बाद म्यूनिसिपैलिटी बनेगा, फिर उससे बड़ा हो जाएगा तो वो म्यूनिसिपल कॉरपोरेशन के अंदर आएगा. तो ये तीनों वाला जो है इसको हायरार्की में रख सकते हैं, बट बाकी हायरार्की में नहीं आएगा. कैंटोनमेंट बोर्ड जहाँ पर आएगा, ये कैंटोनमेंट मतलब आर्मी जो होगा उसके लिए, ठीक है. तो अंडर द प्रोविजन ऑफ द कैंटोनमेंट्स एक्ट ऑफ 2006, a legislation enacted by central government, it works under the administrative control of the defense ministry of the central government. Thus, unlike the above four types of urban local bodies which are created and administered by the state government, a cantonment board is created as well as administered by the central government. ये भी एक डिफरेंस है. कैंटोनमेंट बोर्ड जो है सेंट्रल गवर्नमेंट के अंडर में होता है. द कैंटोनमेंट्स एक्ट ऑफ 2006 was enacted to consolidate and amend the law relating to the administration of the cantonments with a view to impart greater democratization, improvement of their financial base, to make provisions for developmental activities and for matters connected with them. This act has repealed the Cantonments Act of 1924. At present 2019, there are 62 cantonment boards in the country. They are grouped into 4 categories on the basis of the civil population. तो इसका देखो क्लासिफिकेशन है, एक है 1 2 3 4, 4 है बिलो 2500, 3 है 2500 to 10,000, then 10,000 to 50,000 আছে cantonment board 2, then 1 above 50,000. A cantonment board consists of partly elected and partly nominated members. The elected members hold office for a term of 5 years, while the nominated members, ex officio members, continue so long as they hold the office in that station. The military officer commanding the station is the ex officio president of the board and presides over its meeting. The vice president of the board is elected by the elected members from amongst themselves for a term of 5 years. The category 1. Cantonment board consists of the following members: a military officer commanding the station, an executive engineer in the cantonment, a health officer in the cantonment, a first class magistrate nominated by the district magistrate, 3 military officers nominated by the officer commanding the station, 8 members elected by the people of the cantonment area, chief executive officer of the cantonment board. The functions performed by cantonment board are similar to those of a municipality. These are statutorily categorized into obligatory functions and discretionary functions. Discretionary functions: the sources of income includes both tax revenue and non-tax revenue. The executive officer of the cantonment board is appointed by the President of India. He implements all the resolutions and decisions of the board and its committees. He belongs to the central cadre established for the purpose. Then township: this type of urban government is established by the large public enterprise to provide civic amenities to its staff and workers who live in the housing colonies built near the plant. The enterprise appoints a town administrator to look after the administration of the township. He is assisted by some engineers and other technical and non-technical staff. Thus, the township form of urban government has no elected members. In fact, it is an extension of the bureaucratic structure of the enterprises. Port trust: the port trust are established in the port areas like Mumbai, Kolkata, Chennai and so on for 2 purposes: to manage and protect the ports and to provide civic amenities. A port trust is created by an act of parliament. It consists of both elected and nominated members. Its chairman is an official. Its civic functions are more or less similar to those of municipality. बट देखो ये जो टाउनशिप है ये अलग है. इसमें कोई वो जो है एडमिनिस्ट्रेशन ऑफ द टाउनशिप जो है वो क्या है, लार्ज पब्लिक एंटरप्राइज के द्वारा इस्टेब्लिश किया जाता है ये. और इसमें क्या है ना, नो इलेक्टेड मेंबर, कोई इलेक्टेड मेंबर नहीं है, और ये एक्सटेंशन ऑफ ब्यूरोक्रेटिक स्ट्रक्चर है. देन स्पेशल पर्पस एजेंसी: इन एडिशन टू दी 7 एरियाज बेस्ड अर्बन बॉडीज और मल्टीपर्पज एजेंसीज The states have to set up certain agencies to undertake designated activities or specified functions that legitimately belong to the domain of municipal corporations or municipalities or other local urban governments. In other words, these are functional based and not area based. They are known as single purpose, unipurpose and special purpose agencies or functional local bodies. Some such bodies are town improvement trust, urban development authorities, water supply and sewerage boards, housing boards, pollution control boards, electricity supply boards, city transport boards. These functional local bodies are established as statutory bodies by an act of state legislature or as departments by an executive resolution. They function as autonomous bodies and deal with the functions allotted to them independently of the local urban governments, that is municipal corporations or municipalities and so forth, that they are not subordinate agencies of the local municipal body. Of municipal personnel, there are three types of municipal personnel system. In India, the personnel working in urban governments may belong to any one or all the three types. These are separate personnel system. Under this system, each local body appoints, administers and controls its own personnel. They are not transferable to other local bodies. It is the most widely prevalent system. This system upholds the principle of local autonomy and promotes undivided loyalty. Then unified personnel system. In this system, the state government appoints, administers and controls the municipal personnel. In other words, state-wide services cadres are created for all the urban bodies in the state. They are transferable between the local bodies in the state. This system is prevalent in Andhra Pradesh, Tamil Nadu, Uttar Pradesh, Rajasthan, Madhya Pradesh and so on. Integrated personnel system. Under this system, the personnel of the state government and those of the local bodies form part of the same service. In other words, the municipal personnel are the members of the state services, so they are transferable not only between the local bodies in the state but also between local bodies and departments of state government. Thus, there is no distinction between local civil services and state civil services. This system is prevalent in Odisha, Bihar, Karnataka, Punjab, Haryana and others. So the various national level institutions providing training to the municipal personnel are All India Institute of Local Self-Government, Mumbai, constituted in 1927. It is a private registered society. Center for Urban and Environmental Studies, New Delhi, set up in 1967 on the recommendation of Noor Uddin Ahmed Committee on Training of Municipal Employees. Regional Centers for Urban and Environmental Studies, Kolkata, set up in 1968 on the recommendation of Noor Uddin Ahmed Committee on Training of Municipal Employees. National Institute of Urban Affairs, established in 1976. Human Settlement Management Institute, established in 1985. Municipal Revenue. There are 5 sources of income for the urban local bodies. These are as well as tax revenue. The revenue from the local taxes include property tax, तो जो भी ये टैक्स है. नॉन टैक्स रेवेन्यू, these sources include rent or non-municipal properties, fees and fines, royalty, profits and dividends, interest, user charges and miscellaneous receipts. The user charges, payment for public utilities include water charges, sanitation charges, sewerage charges and so on. Grants, so these include the various grants given to municipal bodies by the central and state governments for several development programs, infrastructure schemes, urban development initiatives and so on. Devolution, this consists of the transfer of funds to the urban local bodies from the state government. This devolution is made on the basis of the recommendations of the State Finance Commission. Loans, the urban local bodies raise loans from the state government as well as financial institutions to meet their capital expenditure. They can borrow from the financial institutions or other bodies only with the approval of the state government. The Central Council of Local Government. The Central Council of Local Government was set up in 1954. It was constituted under Article 263 of the Constitution of India by an order of the President of India. Originally, it was known as the Central Council of Local Self-Government. However, the term self-government was found to be superfluous and hence was replaced by the term government in the 1980. Until 1958, it dealt with both urban as well as rural local governments, but after 1958, it has been dealing with the matters of urban local government only. The council is an advisory body. It consists of the Minister of Urban Development in the Government of India and the Ministers for Local Self-Government in states. The Union Ministers act as the chairman of the council. The council performs the following functions with regard to local government: considering and recommending the policy matters, making proposals for legislation, examining the possibility of cooperation between the center and the state, drawing up a common program of action, recommending central financial assistance, reviewing the work done by the local bodies with the central finance assistance. तो यहाँ पर ये चैप्टर खत्म होता है. देखो 243P से लेकर आर्टिकल नंबर दिया गया, सब्जेक्ट मैटर क्या है वो दिया गया. तो 243P से हमने क्या देखा था 243ZG तक. ठीक है. द नेम ऑफ अर्बन लोकल बॉडीज इन द स्टेट्स. तो आंध्र प्रदेश में अर्बन बॉडीज़ का डिफरेंट नेम है और अरुणाचल प्रदेश में देखो ULB मतलब अर्बन लोकल बॉडी डू नॉट एग्जिस्ट. ऐसे कौन कौन है और कोई है क्या स्टेट डू नॉट एग्जिस्ट वाला? तो अरुणाचल प्रदेश में है बाकी किसी में नहीं है, बाकी सब में है। देखो 28 स्टेट्स हो गए, तो एकमात्र अरुणाचल प्रदेश है जहाँ पर कोई अर्बन लोकल बॉडी ULB नहीं है। तो अर्बन जियोग्राफी में जो भी है, तो मतलब उसमें ये चैप्टर पढ़ना बहुत इम्पोर्टेंट है, मेरे को लग रहा है ना। ओके, तो आज का टारगेट यहीं पे ख़त्म होता है, ये वाला हम कंप्लीट कर लिया। ओके, थैंक्स फॉर वाचिंग, थैंक्स फॉर लिसनिंग। और वो मैंने सोचा था कि 2 वीडियो मार्च कर दूंगा, बट वो वीडियो अनएक्सपेक्टेडली स्टॉप हो गया था और ये वीडियो भी काफ़ी लंबा हो गया, तो मैं दोनों वीडियो को अलग ही अपलोड करूँगा, इसको मार्च नहीं करेंगे। ओके, गुड नाइट।